VCY America presents Crosstalk, a nationwide call-in program discussing issues that have an effect on our families, our communities, our churches, our nation, and our world. Crosstalk, an opportunity for you to voice your concerns for biblical principles. And now live by satellite and around the world on the internet at vcyamerica.org. Here is today's Crosstalk.
And welcome to Crosstalk on the VCY America Network. Folks, we're going to be talking about news and issues that you are not hearing from other media sources. As you put on your nightly news tonight, the issues that we're going to discuss today, I can assure you, will not be present. Did you know that the President of the United States was summoned to a Georgia court yesterday regarding his eligibility status as president to show up with documents supporting his birth? Did you know that took place? We're going to be talking about that issue today as we call today's program A Question of Eligibility. It's our privilege to have with us Dr. Herb Titus, a recognized expert on the U.S. Constitution. He has taught constitutional law, common law, and other subjects for nearly 30 years at 5 different law schools. He served as the founding dean of the College of Law and Government at Regent University. Dr. Titus also served previously as a trial attorney and a special assistant United States attorney with the U.S. Department of Justice in Washington, D.C. and Kansas City, Missouri. He's written numerous articles, book chapters, and constitutional studies and analyses. He's the author of God, Man, and Law, the Biblical Principle, and he's the former host of the program That's the Law, which aired daily right here on VCY America. Dr. Herb Titus, nice to have you with us today.
Jim, thank you for inviting me.
Dr. Titus, well before President Obama was elected as president, there were legal proceedings that were underway that questioned his eligibility. These questions and lawsuits have never been satisfied. As I alluded to earlier yesterday, that the president was subpoenaed to appear in a Georgia court in which he never showed up. And we're going to be looking at some of those recent happenings in a short time. But before we get into what's transpired or did not transpire yesterday, it's, I think, important that we start with a foundation for this issue, and that foundation is the Constitution. If you would tell us what the Constitution says concerning the office of presidency, and what are the qualifications for one who is eligible for this office?
Well, first, let's look at the language of the Constitution. It says no person except a natural-born citizen shall be eligible to the office of president. Now, I left out a phrase in there, but it no longer applies because it was specifically addressed to the early history of the country when there wasn't any natural-born citizen who could possibly have held the presidency simply because of the youth of the nation. But today, the key language is no person except a natural-born citizen shall be eligible to the office of president. Now, interestingly, the president is the only one who has to be a natural-born citizen. You don't have to be a natural-born citizen to be a member of the House. You don't have to be a natural-born citizen to be a member of the Senate. And you don't have to be a natural-born citizen to be Chief Justice or a Justice of the Supreme Court or any federal court. So this is a unique requirement that applies only to the eligibility standards for the President of the United States.
So so everything boils down to natural-born citizen and what this means. What did the framers then mean by this statement? You mentioned that there was a change that happened as far as the phrase that you did not read. What did the framers actually have in mind as they put in these words, natural-born citizen?
Well, that's a good question. As some people have pointed out, natural-born citizen is not defined anywhere in the Constitution, and that's true. But on the other hand, you can say, well, there are a lot of other things aren't defined in the Constitution. For example, legislative power, judicial power, executive power. Those are terms that are not defined in the Constitution. And neither is due process of law when you think about it. So there's a lot of language in the Constitution that doesn't have definitions. There are no definitional section. So the better thing to do when you look at a term such as natural-born citizen is to ask the question, well, why would they require the president and only the president to be a natural-born citizen? There must have been some reason for that. And I think that there are some clues in the Constitution why it is that our founders thought it was important for the president to be a natural-born citizen. and it has to do with his oath of office. He is the only officer in the federal government that takes an oath that is actually in the Constitution itself. In other words, all other oaths for all other offices are provided by statute. But the President's oath is specified in the Constitution. Jim, you might remember that when President Obama was sworn in back in 2008, Chief Justice Roberts got some words mixed up.
Mm-hmm.
Do you remember that?
I sure do.
And they actually went back and re-sworn the oath
a second time,
the way it's read in the Constitution.
Mm-hmm.
So the oath must be something that's really important to pay attention to. So let's look again at the language of the Constitution. It says that before entering the office of President, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Now, that's very interesting because not only is that the only oath that's spelled out in the Constitution, but all other oaths follow a different pattern. And that's the pattern set by Article 6 of the Constitution, and that's that all other officers swear only to support the Constitution of the United States. State officers, governors, members of the state legislature, they swear that oath, as do members of the court and as do the members of Congress. But only the President swears to preserve, protect, and defend.
That's very interesting. Mm-hmm.
What this means, then, is that the President is the chief constitutional officer. He's the one who has not only the power but the authority to preserve, protect, and defend the Constitution. Now, if you were in the military, you actually swear the same kind of oath. And the reason being, of course, is that if you're in the military, you're the agent of the commander-in-chief. Mm-hmm. So you're going to take the same oath as the commander-in-chief takes because it's your duty to defend, preserve, and protect the Constitution of the United States. Now, go back to natural-born citizen. What were they looking for in a president? They were looking for a president who had a singular loyalty to the nation. Who better to defend, protect, and preserve the Constitution than a person who has a demonstrable, singular loyalty to the nation? Never been a citizen of any other nation. Wasn't naturalized as a citizen. Well, it would be one who from birth was a citizen of the United States, because then there would be no conflicting loyalty in his relationship to the nation. Now, if you go back and look at the common law, which was a law that was common to all nations, people assumed, and experts wrote, that the meaning natural-born citizen was someone born to parents who were citizens of that state. In other words, whose mother and father were both American citizens. Why is that? Well, because children are influenced by their parents. If their parents are American citizens, then the assumption is that they're going to be taught loyalty to the American nation. If their parents are not the same American citizens, if one's an American citizen and another one is a citizen of France, well, you don't have the same confidence of singular loyalty. And that's the reason why the natural-born citizen provision is in the Constitution.
So that word natural then covers that aspect of both parents then having citizenship here in the United States, whereas a person whom you described who has a nationality where one parent was born in another country, another parent here, they would be deemed a citizen but not a natural-born citizen.
That's correct. And what's important is to realize that being a natural-born citizen is based upon the law of nature. Any natural law is based upon a law of nature, which is revealed by God. And the notion is that no one is accidentally born in any particular nation to any particular parent. You're not born by accident. You're born by design. And who's the designer? Well, God's the designer. So if you're born of two parents, that is a mother and a father, who are of the same citizenship, then you have been ordained by God to be a citizen of the nation of your parents. That's why he's a natural-born citizen. So there's a design in this that goes all the way back to scriptural principles.
Dr. Titus, when this issue has come up time and time again to either the president or his press secretary, they are now referring to the long-form birth certificate that they released in 2011. In your opinion, does the presentation of this long-form certificate as they have given it and said, see, here's the evidence, in your opinion, does this satisfy the matter?
Well, I think it does if your definition of natural-born citizen is that the parents have to be the citizens of the United States, because the form that was produced by the Obama administration indicates that his father was not an American citizen. In the, where people said, well, race, usually you put black and it has African. Well, it shows that he had a national citizenship that was not the United States. And so you don't need anything more than the evidence that's already been furnished by the Obama administration itself. You don't have to go behind it. You don't have to determine whether or not it's a fraudulent certificate. It says it on its face.
Yesterday, President Obama was subpoenaed to appear before a Georgia State Office of State Administrative Hearings. Can you provide any background to this case, what led to the president being summoned there, and what perhaps is different about the Georgia case and any of the previous cases that we've seen go to court?
Well, in this particular case, under state law, the Secretary of State in Georgia has the authority to determine whether a person who is seeking an office is eligible for that office. Now, this is a presidential primary preference election, and so the question was, well, is Barack Obama, whose name was given to the Secretary of State by the Democratic Party, a natural-born citizen? And so, according to state law that governs, there's no federal law that governs this, the Secretary of State has the duty to determine whether or not the person's eligible. That's why this particular case has gone to the merits rather than being dismissed without addressing the merits, because in other cases there was no indication that there was a law at issue.
Dr. Herb Titus is our guest here today on Crosstalk. We're going to take a quick break as we have this constitutional discussion on a question of eligibility. We'll be back in just 1 minute. You're listening to Crosstalk.
Back to Genesis with Dr. John Morris, creation author and president of the Institute for Creation Research.
Dr. Morris, are there any interesting animals that point to design?
Chris, creationists use the woodpecker to show the foolishness of evolution by mutation and natural selection. Each feature on the woodpecker is so well designed, from his tongue to the cushions in his brain to the grasping legs to the tail which braces against the tree. And how about the beak of the woodpecker? It's well known that the beak is strong enough to withstand the rat-a-tat-tat pounding, but it also can open extremely wide, good for catching insects on the fly. Chris, the woodpecker is a superb example of precision engineering on the part of the Creator. Natural selection and mutation would never arrive at such a design. The woodpecker was created along with every other kind of bird on day 5 of Creation Week, and that all happened back in Genesis.
Thanks, Dr. John. For more information, visit us on the web at icr.org. I'm Chris O'Brien. Thanks for tuning in.
You're listening to Crosstalk on VCY America as we're speaking today with Dr. Herb Titus, a recognized expert on the United States Constitution. And we're talking about this question of eligibility, including the current events as up to yesterday, what's taking place in the state of Georgia as this matter is dealt with in the courts. Dr. Titus, we were talking about this concept of natural-born citizen. And that's really where the argument boils down to as to what is meant by this. Is there any biblical support for what you're talking about here?
Well, there is. If you go to Deuteronomy chapter 17, it's a very familiar chapter for Old Testament scholars as well, of course, to people who study the Bible on a regular basis. Back to the period where the Israelites grew tired of the Judge Samuel, the reign of or Samuel as judge, and his corrupt sons. They asked for a king like all the other nations. And that's recorded in 1 Samuel 8. And, of course, God relents and gives them the king. And then in 1 Samuel 10:25, it says they wrote up the manner of the kingdom in a book. Well, what's interesting about that is it doesn't say what the manner of the kingdom was that was in that book in 1 Samuel 10:25. But you can infer that what was in it was what was stated in Deuteronomy 17, because in Deuteronomy 17 it said this, it says, when you enter the land the Lord God is giving you, and you say, let us set a king over like all the nations around us, and it says this in verse 15, it says, be sure to appoint over you the king the Lord your God chooses. He must be from among your own brothers. Do not place a foreigner over you, one who is not a brother Israelite. So there you have it. The law of nature, God's law as revealed in the Holy Scripture, is that the chief officer of any nation should be a native-born citizen in order to ensure singular loyalty. And that's precisely the principle upon which the natural-born citizen provision is in the Constitution of the United States.
Has the U.S. Supreme Court ever had any kind of information, or have they ever had any kind of case or made any kind of decision as to what exactly this means?
Well, there is an 1875 case, which you hear from time to time, a case called Minor versus Happerstedt. There's a paragraph in the case in which the court simply states that a natural-born citizen is a person who is born to a father and a mother, both of which are American citizens. Now, that wasn't necessary to decide the case, although it wasn't the court just talking. And so lots of times people say, yes, but the court didn't hold that, and that's true. But at the same time, it's quite an authoritative statement in a case where this issue came before the court. That's probably the strongest evidence that's out there. There's been scholars and lawyers who've researched the matter a bit more than that and found that in many leading authorities at the time the Constitution was written, that was the meaning of natural-born citizen. And, of course, Jim, what that brings up is the question of the assumption that's been made until more recently, but the assumption that's been made is that if Barack Obama was born in Hawaii, it doesn't matter whether his parents were American citizens. Someone is a natural-born citizen if they're born within the geographic boundaries of the country. And, of course, as you saw in the proceedings in Georgia, both definitions of natural-born citizen were put at issue in the case. There were some lawyers that were emphasizing you have to be born to two American citizens. There was other lawyers who were saying, no, you have to prove that you're born within the geographic limits of the United States. Now, the geographic limits argument is based upon the 14th Amendment, Section 1. And let's again read the language of the Constitution. It says, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. Now, notice it doesn't say they're natural-born citizens of the United States. They basically are just citizens by birth. And you have to see that the 14th Amendment wasn't written for the purpose of defining a natural-born citizen. And the 14th Amendment came into the Constitution after the Civil War. It wasn't there at the time natural-born citizen was first placed in the Constitution. So surely you wouldn't go to the 14th Amendment to find out what a natural-born citizen is. And as a matter of fact, if you do go to the 14th Amendment definition of citizenship, the reason for that definition was to make it clear and certain and fixed that the newly freed slave class were American citizens. And of course, the people who were slaves, brought over here by slaves, none of them were citizens of the United States, unless they were naturalized. And even then there was a fight over that. So you wouldn't go to the 14th Amendment to find out what a natural-born citizen is, and yet that's where the argument's been for several months until most recently.
So the president was ordered then to the state of Georgia with documents supporting his being a natural-born citizen?
Well, he was subpoenaed, and of course, the question is, does this administrative judge, I mean, he's not even a real judge, he's just an administrative judge, does he have any power to require the President of the United States to come to his court and be there and give sworn testimony? I don't know. I don't think so, because I doubt if anyone would think that judge had that kind of authority over the President of the United States, because if you do, then you can put the President into a situation where the court orders him to do something and actually puts him in danger of contempt. So
here, one of the attorneys who argued before the Georgia judge, I believe it was Attorney Van Irion, he said, quote, "We have a president who has openly refused to comply with the legal order of the judicial branch." He said that the president's decision to snub the court system, ignore the hearing, is a dangerous precedent that threatens the foundation of the United States. Do you agree or disagree with that?
I don't agree with that. Main reason is because if you put the president in as a party to a case in a court, then what you do is you compromise his executive authority, which means that he has discretion not to enforce a court order as President of the United States. Again, it goes back to who's the chief constitutional officer. Today people think that judges are. But, judges don't even have authority to enforce their own orders. They have to depend upon the executive branch in order to enforce their own orders. So if you put a president in as a party to a case, then what you're doing is you're compromising his oath of office and his role as the primary constitutional officer. Let me give you an example, Jim. Back in the time of the Korean War, President Truman ordered the seizure of the steel mills because he said, we're involved in a war, there's a strike threatened in the steel mills, we need the steel for the war effort. So he seized the steel mills and took them over to make sure that they didn't shut down. Now, the steel mills challenged the constitutionality of the president's order. Did they sue the president? Answer, no. They sued the Secretary of Commerce. Why? Because of the assumption that they could not exercise jurisdiction over the President of the United States. They could over a lower executive officer, but they couldn't directly exercise jurisdiction over him.
Dr. Titus, we know that the president did not show up yesterday. What happens now in Georgia? I believe there's consideration as to whether or not he should be on the ballot. Is he on the Georgia ballot or is he off the ballot?
Well, that's a good question. Let me just say, just because one party doesn't show up doesn't necessarily mean that they lose. So we don't know whether the court's going to rule in Obama's favor, whether it's going to rule in favor of the people challenging his eligibility. So that's not a foregone conclusion. And it's true of any case. A court doesn't necessarily have to decide a case in favor of the party that shows up and against the party that doesn't. He could enter a default judgment, but that, in a matter of this import would probably not carry the day politically. So I think what you're going to see is this judge going to be very careful to make a recommendation to the Secretary of State according to what he thinks the law is. And then, of course, the question is suppose he recommends to the Secretary of State that the president isn't eligible and therefore cannot appear on the ballot in Georgia. And so the Secretary of State takes him off the ballot. Well, that case can be appealed, and of course, I don't know when the primary is for Georgia, but it's probably going to be expedited in order to make a decision before the primary takes place.
Where does the burden of proof lie with this? Is it with the candidate, or is it with those who are challenging eligibility?
Well, that's a good question. I'm not really sure I know the answer to that. I would think that it would be on the challenger, that the assumption would be that the Democratic Party would not nominate someone that was ineligible, and therefore the challenger would have the burden to prove that the person is not eligible. And I would think that that's probably the case. The Secretary of State doesn't require affirmative proof to get on the ballot that someone's eligible, that it's only if someone's challenged that the eligibility question comes up.
But for them to do that, they would, of course, need the evidence such as the birth certificate.
Well, I think under either theory, you'd have to have the birth certificate. I mean, you can't prove that Mr. Obama's father was other than an American citizen without at least having the birth certificate that was issued by the Obama White House. And that's all you would need. I think that if you take the other tack, the one that says, well, he wasn't born in Hawaii, then I think you've got a much more difficult case to make out on the merits.
There has been called into question the legitimacy of this long-form birth certificate. Is this something that you've looked at as to whether it is legitimate or not?
Well, I haven't made an independent examination of that. I've read what people have said, and of course, with this latest one, there are a lot of allegations that it's a forgery and so forth. I really haven't made a careful study of it. I've certainly have some doubts about it. But again, in my view, I think the question is really who are his parents, not where was he born. And so I don't really have to resolve that question when that's how natural-born citizen ought to be defined, and that is that you are the child of two American citizens.
Do you believe we will see the Supreme Court deal with this issue?
I doubt if the court will touch it. I don't think they would. I think they would rule that it's a political question, it's not a legal question for the court, and there really is no jurisdiction. I mean, think about it for a minute, Jim. We do not elect directly a president of the United States. But we can talk about that when we come back.
Okay. We're going to take a quick break, and tell you what, folks, we're going to open the line so you can start getting on board as well with your questions or comments on this question of eligibility. The number 800-733-9829, 1-800-733-9829. You're listening to Crosstalk on VCY America.
Biblical faith is being undermined and criticized with increasing fervor in schools, on job sites, and in the marketplace. Are you equipped to face the onslaught of secular anti-Christian values and viewpoints? Can you state clearly why you believe in Christ and the authority of the Bible? In the book, In God We Trust, author Steve Ham from Hensers in Genesis will help you identify the influence of the secular worldview and how it attempts to compromise the Word of God. He also helps you distinguish between genuine authority and the counterfeit authority of our day. And he helps the reader realize how your commitment to God's authority will impact your church, your family, and others for Christ. To receive your copy of In God We Trust, send a donation of $16 or more to VCY America, 3434 West Kilbourne Avenue, Milwaukee, Wisconsin, 53208. To make your donation by phone, call 1-800-729-9829. Ask for the book, In God We Trust. That's 1-800-729-9829.
You're listening to Crosstalk here on VCY America. The topic today, a question of eligibility, and we're speaking with Dr. Herb Titus, a recognized expert on the United States Constitution, and we'll get to your calls in just a moment, but just as that break came upon us, Dr. Titus, you were mentioning, and this may be a wake-up call to some people. They said, I thought when I go to the polls in the presidential preference primary or in the November elections that I'm actually voting for the president, but that's not the case, is it?
Well, it's certainly not the case in the general election, but let's talk about the primary. The primary actually doesn't elect anybody.
Right.
As a matter of fact, all it does is identify delegates to the Constitution, and then there's a law that basically commits a certain number of those delegates to vote one way or the other. And, of course, those rules are set by private political associations called political parties. So, for example, let's suppose the Secretary of State in Georgia decides that Barack Obama is not eligible to be on the presidential primary, and the presidential primary is conducted, and his name isn't there. Well, I'm sure that you'll probably find a whole bunch of people who write in his name or something like that. But what difference does it make whether he wins the Georgia presidential primary or not? Is the Democratic Party really going to exclude anybody from Georgia coming to the Democratic National Convention and voting for Obama to be their candidate for president? Of course not. I mean, all the Democratic Party would do would be to thumb their nose at Georgia. I mean, they can't determine that. So in a way, this is a symbolic fight more than a real practical fight, because you're not going to actually impact the national party legally.
Let's talk about that general election.
Well, the general election is even a bit more complicated, because in a general election, while the name of the presidential candidate is on the ballot, you're not really voting for him or her. You're voting for the electors that are oftentimes also named on the ballot. Sometimes they're not named on the ballot, but it's actually the electors in the Electoral College that you're voting for. And the president isn't elected on the first Tuesday of November of 2012. He's not elected until mid-December, when the Electoral College meets, and they meet separately in each state at the state capitol. It's at that point that the president is actually elected.
Dr. Titus, there is a move presently going throughout the country right now, state by state, to, in essence, make null and void this electoral college, not remove it, but focusing rather on a national popular vote as opposed to the electoral college. Do you see danger in that?
Oh, yes, I do. And, of course, the first thing is I don't think that the states can change the rules of the game. I don't think they can require electors of a state in which a particular candidate got the majority and got those electors. I don't think they can override that by saying those electors have to vote for someone who won the overall national vote. I think you have to change the Constitution before you could change that particular rule.
Yeah, many states are doing that right now.
Yeah, well, and I'm not so sure that I don't think it's a good idea, because I think what it does is it destroys the federal system. It destroys the important principles of diffusion of power, so that we don't have this totalitarian central government. And that's what it's going to lead to. If you go to a completely democratic system by which you elect the President of the United States, then you're just simply going to concentrate more and more power in Washington, D.C., and less power in the states.
Let's go to the phone lines. We have our first caller right here from our home city of Milwaukee. Dawn, you're on the air.
Hi, I had a comment and a question. My comment is, when I applied for my driver's license, I had to have a birth certificate. Does Obama have his license, and if he does, then he has a birth certificate. And my question was, if I was subpoenaed by an administrative judge and I didn't show up to the court hearing, would I be in contempt of court because I'm not the president?
Dr. Titus.
Well, I think, Don, you wouldn't be in contempt of court unless you were somehow more closely associated with the state of Georgia than you are right now. If you live in Milwaukee, There's no state court that I know of that has authority to subpoena somebody who lives in another state and has not set foot in Georgia and has nothing to do with a particular issue in the state of Georgia. So there are limits to any court's power, and they're usually jurisdictional limits based upon political boundaries.
And go ahead, Dawn.
Oh, I was just going to say thanks for answering my question.
Mm-hmm. Appreciate your call.
Thank you.
And Dr. Titus, pertaining to the driver's license issue, I mean, the president would say, I've shown my birth certificate. This is it.
Well, I don't think that driver's license people pay that much attention. They don't examine whether the birth certificate is valid or not valid. It's pretty much a ministerial act, and they trust people. I mean, it's sort of like, when people go register to vote. I don't think that you have anyone going out and making an investigation to make sure you live at the address that you gave to the election board and that you are eligible necessarily to vote.
Let's go to Port Huron, Michigan, and Harry, you're on the air.
Hey, fellas. As far as I'm concerned, I think it's time to move on. You were asking what do people think. I think this whole process it's just. What about the people that come here to this country they do it the legal way? They're legal citizens. There's a lot of good people that come here in this country, and they're hard-working people. Quite frankly, I think they'd be better presidential fathers than a lot of the candidates that we have today. I think we miss out on a lot of things, and that's not the only thing that needs to change in our political process. There's a lot of things we could talk about, but I think it's time to move on. And plus, if the courts rule against the president, we all remember what happened in '92, right, with Rodney King? It was horrible what happened with the riots and things. I am very concerned that if the courts rule against him, it's going to make Rodney King look like a walk in the park.
Dr. Titus?
Well, I think the caller has got a couple of good points, but let me just say to you, I don't think that you're going to see any court in this country rule that anybody, whoever they might happen to be, is ineligible to serve as President of the United States. I think that the courts would defer to the people on that. They'd say it's the people's decision as to whether or not he's a natural-born citizen. It's a political question. It's not going to be legally resolved, and therefore we're not going to intervene. So I don't think you're going to have that. And that's what's happened with the courts over and over again. They just simply refuse to address the question and basically say it's for the people to decide. I'd like to pick up the other point the caller just made because I think it is an important point, and that is that just because someone's a natural-born citizen doesn't necessarily mean that they are of one heart and one mind for the nation. And indeed, I think we've seen people who've come over here from Eastern Europe, from other countries, who love America more than natural-born citizens love America, and who are more likely to be singularly loyal to America than many natural-born citizens. So the caller is correct. There is no guarantee just because someone's a natural-born citizen that he's going to have that singularity of allegiance. But nonetheless, that's the requirement of the Constitution. But I do think it's essentially a political question that should be resolved by the people and not by courts or any other official government agency.
Thank you, Harry, for your call. So as far as determination of what natural-born citizen means, it would be your preference, Dr. Titus, for a court not to handle that?
I just think there are some questions, some constitutional questions, that are outside the providence of courts. Today, we're so used to thinking that every constitutional question has to be resolved by the United States Supreme Court, and once the United States Supreme Court resolves it, then everybody has to be in lockstep and follow the Supreme Court of the United States. That's not the American system. It was never designed to be a monolithic system in which all ultimate legal and political questions are resolved by a body, especially by a body that's basically unelected.
Let's pick up our next call. From Burlington, it's Edie. You're on the air, Edie.
I have a question. One is that a lot of these cases have come forward, and judges have said time after time that nobody has any standing and nobody can, in essence, they're saying nobody can question the president. He's just absolutely untouchable. When we're sitting in the situation that we are, with all of the blatant abuses of the Constitution that this president has done, it seems to me that, and as far as the people determining this, I've heard a huge outcry from the people that's being totally ignored as to the fact that he is not eligible and that he has done things that are impeachable offenses, hugely impeachable. So I have a problem with that. I also have a problem with the idea, it seems like Christians in particular, it's all about, the rule book and the playbook. Well, yes, it is to a degree. And yet what happened within the Electoral College and the Democrats and all the goings-on that was happening there was more like a flash mob than following any rules about vetting him. So much has gone on in this country this way. We talk about the niceties of, following the rules, and yet the reality is the mob still does rule, and it's time for that to stop. It is time to go back to the Constitution as it is written, and to, yes, let's talk about what this whole issue of eligibility really is in the courts. It's got to be established because this has happened too many times.
Edie, thank you for your comment here. Dr. Titus, and I'll have you respond to Edie and also join with that the answer to this, that if we disregard one aspect of the Constitution, such as what this means as far as a natural-born citizen, as she was pointing out, we're seeing many other constitutional abuses. So does disregard of one part of the Constitution lead to a plethora of abuses of other parts of the Constitution?
Well, it tells you something about the nature of the American constitutional system. It was never designed to have one institution out of all of the different governing institutions to make the final decisions. And there was a danger in that because that's the kind of thing that leads to totalitarianism, it leads to authoritarianism, and so it's kind of messy out there. But Edie's point is a very important one, and that's that the people have a responsibility here to make sure that the Constitution is followed as it is written. If people don't like the natural-born citizen requirement, then they can amend the Constitution. I think in this particular case, it demonstrates why the natural-born citizen requirement is so important, is because I think this president does have a divided loyalty. I think he is more loyal to his African father than he is to the American nation, and I think that's been well documented. So I do believe that we need to have that kind of responsibility. But, Edie, I think you overlook the responsibility that Congress has, and the Congress doesn't exercise its constitutional prerogatives. That's one of the things. You're overlooking also that state officers, legislative and executive officers, they too take an oath to support the Constitution. Why aren't they defending what the Constitution says?
Good question. Dr. Herb Titus is with us, and we'll come back for the final segment with more of your phone calls here on Crosstalk on A Question of Eligibility. We'll be right back.
For the Worldview Weekend Minute, I'm Brandon House. Our website's worldviewweekend.com. Have people like Bill Bright, Chuck Colson, and even Billy Graham helped to bring the religious Trojan horse into the camp of evangelicalism? All three of these men have received the Templeton Prize. Billy Graham in 82, Colson in 93, and Bright in 96. John Templeton was a man who was into spirituality, New Age teachings. He said that we need the next stage of, quote, human divine progress on the evolutionary scale. He went on to talk about the need to develop, quote, a body of knowledge about God that does not rely on ancient revelations or scripture, end quote. Why would any Christian leader accept the prize and the money that goes with the Templeton Foundation's movement and goals? Is very striking. Indeed, I believe it's possible that some of the men that have been upheld as some of the greatest leaders of evangelicalism have in fact helped to introduce the religious Trojan horse inside the camp of evangelicalism. Jude 3, 2 Peter, and Acts 20 warn of this. For the Worldview Weekend Minute, I'm Brandon House.
Dr. Herb Titus with us today, expert on the U.S. Constitution, and has taught constitutional law, common law, and other subjects for 30 years at 5 different law schools, been involved in much, well, has got a great legal background. We can't go through the full bio here again, but Dr. Titus, I want to make sure that we do get out a website for those who'd like more information on this and related issues.
Well, our law firm, William J. Olson, P.C., is in Vienna, Virginia, and you can find us on the web, lawandfreedom.com. We do a lot of constitutional litigation in a number of areas, including the Second Amendment, the First Amendment, and a number of other matters involving liberty. So you go to our site and you find out what we're doing and what we're writing.
lawandfreedom.com.
That's right.
Let's go next to Ty. You're on the air. Ty, go ahead.
Yes, thank you. Barack Obama, as far as talking about following the Constitution and swearing to uphold it, defend it, as a senator in Illinois, he was on the radio and he was quoted as saying, "I don't like the Constitution. It tells me not what I can do, but what I can't do." And since he also said while he was running as the president that he wanted to fundamentally change the country, well, to do that, you have to go against the Constitution, and his record has shown that he has clearly done that, gone against the Constitution and stomped on it. So is there some kind of way that we can make him uphold his oath, since he has broken his oath to uphold and defend the Constitution, and clearly he hasn't, and he's indicated previously to being elected that he didn't want to?
Okay, good question, Dr.
Well, there are two things. One, of course, is the vote, and I would assume that people who share your view are going to be voting in November and making sure that Mr. Obama doesn't return to the White House. The other thing, of course, is where's the Congress on this? The Congress has authority to impeach the president, the House does, and the Senate has the authority to try someone on charge of impeachment. But we haven't seen much talk along that particular line, no matter what this man's pattern is with regard to constitutional abuses. Unfortunately, we've seen too many presidents over the years pay little attention to the Constitution, so it's very difficult to single out one president as contrasted with others, even when it appears that the action of this president is so egregious.
Thank you, Ty, for your call. We're going next to Vic calling from Fall Creek. You're on the air.
Yeah, Dr. Titus, I have a couple questions. Some states, and I'll mention the questions and then I'll bow off so you can answer. Some states, Arizona being one, and I don't know how many others, have stated that for the upcoming election, that in order for a candidate to be on the ballot, the candidate has to prove their eligibility for the position, which would be president, of course. So, what do you see as far as a problem with, can Mr. Obama skirt this somehow, or if he can't establish his rightful or his natural, the eligibility requirement, and the respective state doesn't put him on the ballot, then what do you foresee happening here? And secondly, like Edie and Ty just said, there doesn't seem to be a whole lot of accountability anymore with Congress in actually keeping the president honest. And in a recent comment regarding Mr. Obama making those appointments before the Congress was on recess, which was a violation of the Constitution, Nancy Pelosi was recorded, and I heard her say this, that, we haven't got time to follow the Constitution. We had to get such and such a business done. I could have blown a gasket when I heard that, but there's so little accountability with Congress, and I know I'm a voter, but unfortunately in our society, we've got so many voters that seem to be indifferent to this, or even they don't understand this.
Thank you, Vic. Appreciate that. Dr. Titus, your comment.
Well, I believe you're right. I mean, I think it's because too many children are taught in government schools, and the government teaches people to do what the government wants them to do, and I think we've seen that grow and grow and grow. So it begins really with how are our children are taught, and why is it that so many people are perfectly willing to go along with it? The other thing, of course, is the whole issue of entitlements. There are a lot of people who vote for candidates because they think that that's going to assure them their Social Security or their Medicare or whatever else they think they're entitled to from the government. So we have a breakdown in the electorate, primarily because we have a breakdown in government. Most of these programs are unconstitutional. So, it can be very frustrating, but it doesn't mean we shouldn't vote. It doesn't mean that we shouldn't argue and contend, and it doesn't mean that we shouldn't be calling up and urging our members of Congress to do their duty.
Let's pick up Ann in Menominee Falls. You're on the air.
I'd like to read you something from the book A Nation in Crisis by Larry Bates.
Okay, we've got just about 90 seconds left in the program, Ann.
Gee. Well, he says on page 14, he says he was in the Kenyan-born Obama all set for the U.S. Senate in, this is when June 27th, 2004. This report explains the context of the often-cited debate between Obama and former U.S. Ambassador to the United Nations, Alan Keyes, Obama's opponent for the Senate seat. In the debates during the fall of 2004, Keyes would fault Obama for not being a natural-born citizen. And for Obama's quick retort, so what? I'm running for Illinois senator, not the presidency.
Okay, we're going to have to stop there. A comment, Dr. Titus.
Well, typical expedient comment by a politician.
Okay, legit. I mean, if that was a truthful comment, that would disqualify he and him own self would disqualify himself for president. Wow. And very quickly, a few seconds, we have Steve in Florida. You're on the air.
Jen, did I hear about 4 or 5 callers back state that we should simply move on and not pursue this eligibility question?
One caller stated that, yes.
That is exactly why judgment has entered this nation. I would ask that person to repent, and all other people that think this is not worth pursuing. If you are a Christian, fall on your knees, repent, because judgment is going to get worse.
That's Steve. Thank you for your comment here today. Well, folks, that's all the time we have. Dr. Herb Titus has been our guest here today. Thought-provoking discussion. And again, Dr. Titus, if you would give us that website.
lawandfreedom.com.
Great. Well, thank you for the discussion here today on this issue and helping us to have a good understanding as to the Constitution, what it says, what it doesn't say here in this regard. And Dr. Herb Titus has been our guest today. Thanks for joining us on Crosstalk.
You've been listening to Crosstalk via satellite and the internet from VCY America. Views expressed may or may not be those of this station. For a CD of today's program, send a donation of $6 or more to VCY Take Ministry, 3434 West Kilbourne Avenue, Milwaukee, Wisconsin, 53208, or download by RSS or podcast from crosstalkamerica.com. And join us again for Crosstalk.